state when the lease violation occurred, describe the lease violation, identify the person, if you can, who committed it. Now, this is where the ordinance becomes extremely, extremely important. The ordinance says that the 10-day notice must advise the tenant of his or her right to cure the alleged violation, provided it can be cured within the 10-day period or before the termination notice expires. Right? This is extremely important, and I would argue that a notice that does not provide that language, a notice that does not inform the tenant of his or her right to cure, is invalid, and therefore is not sufficient to support subsequent forcible action. There will be a lot of arguments about what activities can and cannot be cured. I think most activities can be cured. I mean, obviously, if the tenant runs outside and takes a shot at the landlord, I don't think there's anything the tenant can do to cure that, especially if he hits the landlord. But the most common situation you'll see is one in which the head of the household didn't actually do something wrong, but a member of the household did. In those situations, you may be able to cure by getting rid of the bad actor and barring that person from ever returning to the unit. Then there are a lot of other actions that can be cured. Let's say you broke a window. Well, if you pay for the repair of the window, that's probably sufficient. I had one case in which a CHA resident had accrued a $10,000 gas bill over a period of more than 10 years. And the reason it was so high is because the gas company was not able to shut the service off from the street. The meter was in the unit. And so the gas company actually had to get a replevin order, come into the unit, remove the meter, and then CHA said, well, look, it's your responsibility to maintain gas service. You haven't done it. This is a violation of your lease agreement. You've got 10 days to cure. And so the way we cured is we filed a Chapter 7 bankruptcy petition, wiped out the debt to the gas company, and the gas company had to come back and restore the meter within the 10-day period, and CHA said, fine, we're fine with that. That's all right. I do have to say that when I talked about this case down at the University of Chicago, which is a fairly conservative law school, the whole law and economic theory, the whole school of thought came from there. I thought people were really going to think, boy, that's good lawyering. And there was just this stunned silence. And then one of my students just said, that's bullshit. and so then that led to kind of an interesting discussion of, how is it really? And what about corporations that file bankruptcy? I'm not going to get into all that. Other kind of notices you might see are 7-day notices or 30-day notices. These are notices to terminate week-to-week or month-to-month lease agreements. Okay, very often the person will not have a written lease agreement; they'll just pay rent every month. They have a lease agreement; it's just not written. It's an oral lease agreement. It runs month to month. It can be terminated without good cause. Okay, upon 30 days advance written notice. If somebody's paying rent week-to-week, they have a week-to-week tenancy, which can be terminated without good cause upon 7 days advance written notice. Again, Hank, I'm sorry I keep mentioning subsidized housing. In most subsidized housing cases, just in case you start working on them, 7-day and 30-day notices are completely invalid if they do not set forth a reason for terminating the tenancy. It's because in public housing context, in Section 8 project-based developments, the tenants have endless lease agreements. They automatically renew themselves at the end of each term unless they are terminated for good cause. So they can't be terminated without good cause. Tenants who have a Section 8 voucher, their lease agreements cannot be terminated without good cause during the term of the lease. But when the lease ends, they can be terminated without good cause. And the reason that that's acceptable is because in those cases, the rental assistance runs not with the unit, but with the tenant. So the tenant is not losing her rental assistance when her lease agreement is terminated and she has to move because she can just take her assistance with her. Now, if you get a tenant who brings to you a 7-day or 30-day notice that does not state good cause for terminating the tenancy, one thing you're going to want to discuss with your client is whether the landlord has some illegal motive for bringing this eviction action. And you might just want to say to the tenant, well, why do you think the landlord is evicting you? Because very often in these cases, the landlord has a retaliatory motive or an illegal discriminatory motive for terminating the tenancy, and obviously the reason they don't want to set forth the reason for terminating the tenancy is because their reason is illegal. Now, the Forcible Act, Section 211 of the Forcible Act, states how the notice must be served. And it has to be served by handing a copy to the tenant. Yes, Mr. Golden.
Voucher-based Section 8, City of Chicago. If you don't want to extend the tenancy after it ends by its own term, does it require a 30-day notice if not renewal?
Yes, it does.